Industrial Dispute Act 1947 for departmental exam, in-service exams, PSC exams, UPSC exams, UGC NET exam, degree PG level exams and various other exams. Industrial Dispute Act 1947. The act intends to minimize the conflict between labor and management and to ensure as far as possible economic and social justice. The object of the act is to make provision for the investigation and settlement of industrial disputes. Appropriate government. The central government shall be the appropriate authority in relation to any industrial dispute concerning in the following industry or organizations. Authority of the central government, a railway company, dock labor company, the Industrial Finance Corporation of India Limited, the Employees State Insurance Corporation, the Board of Trustees constituted of the Coal Mines Provident Fund and Miscellaneous Provisions Act, Life Insurance Corporation of India, Oil and Natural Gas Corporation Limited, Unit Trust of India, the Industrial Reconstruction Bank of India Limited, etc. etc. Average pay. Average pay means the average of the wages payable to a workman. In the case of monthly paid workmen in the 3 complete calendar months. In the case of weekly paid workmen in the 4 complete weeks. In the case of daily paid workmen in the 12 full working days. Award. Award means an interim or a final determination of any industrial dispute. I repeat, average pay. Average pay means the average of the wages payable to a workman. In the case of monthly paid workmen in the 3 complete calendar months. In the case of weekly paid workmen in the 4 complete weeks. In the case of daily paid workmen in the 12 full working days. Award. Award means an interim or a final determination of any industrial dispute. Section 10A of the Act. Industry. Industry means any business, trade, undertaking, manufacture or calling of employers and includes any calling, service, employment, handicraft or industrial occupation or avocation of workmen as per Section 2J of the ID Act 1947. Municipality as an industry. Cases D.N. Banerjee versus P.R. Mukherjee, Nagpur Corporation versus its employees. Hospital as industry. Cases State of Bombay versus Hospital Mazdoor Sabha, Management of Safdarjung Hospital versus Kuldeep Singh Sethi. Education as industry. Cases University of Delhi versus Ramnath. Club as industry. Madras Gymkhana Club Employees Union versus Management of Gymkhana Club. Then industrial dispute. The Industrial Dispute Act 1947 defines industrial dispute as any dispute or difference between employers and employers, or between employers and workmen, or between workmen and workmen, which is connected with the employment or non-employment or the terms of employment or with the conditions of labor or of any person as per Section 2 subsection K of the Act. Section 2A of the Act pertaining to dismissal etc. of an individual workman states that where any employer discharges, dismisses, retrenches or otherwise terminates the services of an individual workman. The collective bargaining parameter is inclusive in the definition of industrial dispute as is evident from Section 2A of the Act. A dispute between the employer and a workman will not be an industrial dispute unless it is sponsored by the union or a substantial number of workmen. A dispute between the employer and an individual workman cannot an industrial dispute. Cases CP Transport Service Nagpur versus R. Gopal Patwardhan, Newspaper Limited versus Industrial Tribunal UP, National Asphalt Pro Construction versus Kothari. Bombay Union Journalist versus Hindu Bombay. State Transport Controller Orissa versus Presiding Officer Industrial Tribunal Orissa. Layoff. Layoff. With its layoff means the failure, refusal or inability of an employer or on account of shortage of coal, power or raw materials, or the accumulation of stocks, or the breakdown of machinery, or natural calamity, or for any other connected reason to give employment to a workman whose name is borne on the muster rolls of his industrial establishment and who has not been retrenched. Section 2, subsection KKK. Then, lockout. Lockout means the temporary closing of a place of employment or the suspension of work or the refusal by an employer to continue to employ any number of persons employed by him. Public utility service. Public utility service means railway service, major port or dock, industrial establishment, postal telegraph, industry which supplies power, light or water to the public, etc. etc. Relevancy of public utility service. Where the industrial disputes exist or is apprehended, the conciliation officer may, or where the dispute relates to a public utility service and a notice under section 22 has been given, shall hold conciliation proceedings in the prescribed manner. Similarly, the appropriate government will have to refer the dispute to adjudication if the dispute relates to a public utility service and notice under section 22 of the Act has been given for a strike. As per section 22 subsection 1 of the Act dealing with the prohibition of strikes and lockouts, no person employed in a public utility service shall go on strike in breach of contract. Retrenchment. Retrenchment means the termination by the employer of the service of a workman for any reason whatsoever otherwise than as a punishment inflicted by way of disciplinary action, but does not include voluntary retirement of the workman. Retirement of the workman on reaching the age of superannuation. Termination of the service of the workman as a result of the non-renewal of the contract. Termination of the service of a workman on the ground of continued ill health. Then settlement. As per section 2 subsection P of the Industrial Dispute Act 1947, settlement means a settlement arrived at in the course of conciliation proceedings and includes a written agreement between the employer and workman arrived at otherwise than in the course of conciliation proceeding where such agreement has been signed by the parties thereto in such manner as may be prescribed, and a copy thereof has been sent to an officer authorized in this behalf by the appropriate government and the conciliation officer. Case PC Bani versus Indian Overseas Bank. A private settlement will be binding only on the person who has signed in the agreement with the employer. Cases Tata Chemicals Limited versus its workman. Publication of reports and awards. Section 17 of the Industrial Dispute Act 1947. Case Coromandel Fertilizers Limited versus Venugopal. Persons on whom settlements and awards are binding. Section 18 of the Industrial Disputes Act 1947. Case Tata Chemicals Limited versus its workmen. I repeat, persons on whom settlements and awards are binding. Section 18 of the Industrial Disputes Act 1947. Case Tata Chemicals Limited versus its workmen. Strike. Strike means a cessation of work by a body of persons employed in any industry acting in combination or a concerted refusal or a refusal under a common understanding of any number of persons who are or have been so employed to continue to work or to accept employment. Trade union. Trade union means a trade union registered under the Trade Union Act 1926. Tribunal. Tribunal means an industrial tribunal constituted under Section 7A and includes an industrial tribunal constituted before the 10th day of March 1957 under this Act. Unfair labor practice. Unfair labor practice means any of the practices specified in the 5th schedule. Wages. Wages means all remuneration capable of being expressed in terms of money, which would, if the terms of employment expressed or implied were fulfilled, be payable to a workman in respect of his employment or of work done in such employment. Wages does not include any bonus, any contribution paid or payable by the employer to any pension fund or provident fund or for the benefit of the workmen under any law for the time being in force. Any gratuity payable on the termination of his services. Wages does not include these. Workman. Workman is any person employed in any industry to do any manual, unskilled, skilled, technical, operational, clerical or supervisory work for hire or reward as per Section 2 subsection S. Section 2 subsection S of the Industrial Disputes Act 1947. Cases: Devinder Singh versus Municipal Council, Chintaman Rao versus State of Madhya Pradesh. Then supervisory work. A person working in purely managerial or supervisory capacity does not fall within the definition of workman under the Industrial Dispute Act. A managerial work includes powers and duties related to hiring and firing of new employees, grant of leave to employees, and actual participation in the policy of the business. Cases: Delta Jute and Industrial Limited Staff Association and OAS versus State of West Bengal. Another case: Ved Bengal Gupta versus Messrs. Deccan Cables India Private Limited. Another case: Rohtas Industries Limited versus Ramla Khan Singh. Okay. Then apprentices. Section 18 of the Apprentices Act provides that apprentices are trainees and not workers, and provisions of any law with respect to labor shall not apply to or in relation to such apprentices. Case: Uttar Pradesh State Electricity Board versus Shiv Mohan Singh and another. Then government servant. Workmen as applicable to the Industrial Dispute Act does not include persons engaged by the government who are governed by constitutional provisions, or in other words, it does not include civil servants who enjoy protection under Articles 310 and 311 of the Constitution of India. Individual dispute considered as industrial dispute. Section 2A of the Act deals with the dismissal, etc., of an individual workman, where any employer discharges, dismisses, retrenches, or otherwise terminates the services of an individual workman. Any dispute or difference between that workman and his employer connected with or arising out of such discharge, dismissal, retrenchment, or termination shall be deemed to be an industrial dispute, notwithstanding that no other workman nor any union of workmen is a party to the dispute. An individual dispute other than those which are covered under the provision of Section 2A of the Industrial Dispute Act 1947, that is for dismissal, discharge, termination, or retrenchment, will be considered as an industrial dispute under section 2 subsection K only if it is supported or espoused by a trade union. Workmen of industrial case, workmen of Indian Express versus management of Indian Express. Workers of Western India Match Co. versus their workmen. Sham versus State of Haryana. Chandrakanta Tukaram Nikam and versus Municipal Corporation of Ahmedabad and now. Then another case, Bank of Baroda Ahmedabad versus its workmen. Authorities under Industrial Dispute Act. Various authorities constituted under the Industrial Dispute Act 1947 are Works Committee, Conciliation Officer, Board of Conciliation, Court of Enquiry, Labor Court, Industrial Tribunal, National Tribunal, and arbitrators. Thank you.